Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering Supreme Court obliterates illegal hiring practices. DEI is dead. Coming from CNN, Supreme Court signals it will make it easier for Americans to file reverse discrimination lawsuits. And from the Washington Post, her claim of anti-straight bias could upend discrimination law. The Supreme Court is hearing a case that could unleash a wave of workplace bias claims by whites, men, and people who are straight. And also from the Washington Post, Supreme Court seems poised to lower bar for whites to sue for job bias. Marlene Ames challenged rulings requiring members of majority groups to meet a higher bar to prove job discrimination than groups that traditionally face bias. That standard is unconstitutional. It's also nowhere in law. It's just a practice that some circuit courts and appeals courts have followed. Well, not anymore. From the Washington Post, her claim of anti-straight bias could upend discrimination law. And none of this is changing any laws. All this is interpreting the Constitution correctly, that every human being, based on their immutable characteristics, deserves the same opportunities as everyone else. Not that they're entitled to them, they're deserved to try to get to those opportunities, to have a chance to succeed. Marlene Ames was distraught in 2019 when she was bumped from an administrator position at the state agency overseeing youth corrections and replaced by a gay man who she says was less qualified. Ames was demoted and her pay was cut more than $40,000. A few months later, she lost a management job she had applied for to a woman who had not sought the position initially, according to a lawsuit that she would soon file. That woman, too, was gay. Ames's job discrimination lawsuit makes an unusual claim that could upend how many of the nation's courts have handled such cases for decades. The department, she says, was biased against straight people like her. The Supreme Court has already heard oral arguments on this case. And here's what they had to say. The Supreme Court seems poised to lower bar for whites to sue for job bias. And it really wasn't just about her skin color. It was about her losing jobs to people that said they were gay. The Supreme Court on Wednesday appeared to support the idea of making it easier for men and people who are white or straight to sue for job discrimination based on oral arguments in the case of an Ohio woman who claimed she faced anti-straight bias in the workplace. The High Court's conservative supermajority and at least some of the liberal justices seemed receptive to arguments by Marlene Ames, who is challenging rulings by many of the nation's courts that require members of majority groups to meet a higher standard to prove job discrimination than groups that have traditionally faced bias. And if you think of this just logically, how are you supposed to know, as an employee of a company or someone even going to work at a company, whether or not they discriminate against people based on their skin color, sexual preference, race, or any other reason they might come up with? Are they equal opportunity employers or not? Should you develop a career at a company when the company is not going to take you seriously or give you promotion opportunities, or in this case of this woman, actually demote you and take $40,000 of your pay away? How are you supposed to go work for a company and not know at the very least that this company does these kinds of things to their employees? If companies are going to behave this way, and a lot of them are going to stop behaving this way, they at least would have to warn the potential employees and the existing employees, look, we do discriminate against people because we want to give opportunities to these kinds of people or those kinds of people. So if you're trying to make a career here, stop wasting your time, because we're going to give these opportunities to other people that are not as qualified as you because we just kind of feel like doing it. We think it's the right thing to do. And I've never heard of a company that was honest and upfront like that and told people, sure, we discriminate and this is how and why we do it. They always talk about giving opportunities to other people and, okay, sure, it's implied that you might be excluded from certain opportunities if you don't meet one of their favorite groups. But not all companies treat that the same way, which is why every company that gets involved with doing anything discriminatory like this, at the very least, should be disclosing to their employees how they do business. And then an employee can decide, do I want to still work at a place that does things like this? Because it's unethical, it's unprofessional, and most importantly, you don't even have a future at that company. The Supreme Court justices appear ready to strike down the test. Both conservative and liberal justices peppered the Ohio Solicitor General over the state's opposition to Ames's arguments. This is actually the state of Ohio that this employee has to sue. And it's the state of Ohio that's defending this discriminatory behavior. It's incredible. Eventually, the Ohio Solicitor General, who is defending against this lawsuit for the state of Ohio, was pushed to finally admit that he too thought minorities and members of majority groups should be treated equally. Quote, "We're in radical agreement," said Justice Neil Gorsuch, a striking statement for a court that has sharply divided along ideological lines in recent years on issues from abortion to affirmative action. Ames, a straight white woman, which really is that any of our business? It ought not to be. Whoever she's attracted to, why is that the business of her employer? Why is that something that's even being discussed? Maybe she'll change her mind and try to go a little freaky on the wild side. That's her business. Maybe she'll change her mind and decide to change her sexual preferences. That's up to her. It should have nothing to do with her work environment. But she did file a job discrimination lawsuit in 2020 after she was removed from her job as an administrator at the Ohio government agency overseeing juvenile corrections. Her position was given to a younger gay man. Ames said she was also unfairly passed over for another management role, which went to a woman who Ames considered to be less qualified. Ames said the woman, who was a lesbian, had not initially expressed interest in the job. They just tracked her down because she was gay, and they said, "Hey, you're gay. Would you like a promotion?" And the woman's like, "Okay, I'll take it. Do I get more money?" Of course you get more money. Something does seem a little wrong about that. The job discrimination lawsuit Ames filed against the Ohio Department of Youth Services did not do so well in the federal courts in Ohio. There, and in many other U.S. appeals courts, plaintiffs must prove discrimination claims through direct evidence or by mounting a circumstantial case because evidence of workplace bias can be hard to obtain. Those courts require members of majority groups mounting a circumstantial case to meet an extra burden of proof not required of minorities, known as background circumstances. White people, straight people, and men must show their employer is the unusual one that discriminates against majority groups, which have not historically faced discrimination. Although we've now come to understand that it's not unusual at all. Lower courts ruled against Ames before her lawsuit went to trial, finding that she was unable to meet the background circumstances standard. On Wednesday, a lawyer for Ames argued that the standard fundamentally violated a portion of the landmark 1964 Civil Rights Act that outlaws discrimination in the workplace based on sex, race, color, religion, or national origin because it treats groups differently based on their background. Zhao Wang pointed the justices to an inscription carved on the outside of the High Court. Quote, "Equal justice under the law." Quote, "All Ms. Ames is asking for is equal justice under the law," Wang said. "Not more justice, but certainly not less. And certainly not less because of the color of her skin, or because of her sex, or because of her religion." And that argument seemed to resonate with the justices. In her questions to T. Elliott Gazer, the Ohio Solicitor General, Justice Elena Kagan highlighted a passage from a lower court ruling in Ames's case that she said was absolutely critical. Quote, "Because Ames is heterosexual, she must make a showing in addition to the usual ones for establishing a case," said Kagan. Quote, "And then it says, Ames's case would have been easy to make had she belonged to the relevant minority group here, gay people." Justice Brett Kavanaugh, a conservative, picked up the thread. Quote, "You agree those passages are wrong?" Gazer, the Solicitor General, conceded that he did. Quote, "I think the idea that you hold people to a different standard because of their protected characteristics is wrong," he said. Gazer told the justices that Ohio was less interested in defending the background circumstances standard than arguing that Ames had simply not met the burden of proof in her case. He said it would have failed regardless of the standard because she was not able to marshal evidence of anti-straight bias. The NAACP Legal Defense and Education Fund made a forceful argument in favor of the standard in a friend of the court brief. The group said that different standards for majority and minority groups were appropriate because of the nature of inequality in America. Black people and those in other minority groups have historically been the target of bias, while reverse discrimination is relatively rare. Except for the entire national corporate and government movement of diversity, equity, and inclusion, because no, it's not actually rare. Corporations and employment lawyers are closely watching the case because many think a ruling in favor of Ames could unleash a wave of workplace discrimination claims by white people, straight people, and men. Wang discounted that idea, saying the appeals courts that don't employ the background standard have not seen a larger number of reverse discrimination cases. The case coincides with President Donald Trump's assault on diversity, equity, and inclusion initiatives. Trump has issued executive orders targeting DEI programs in the federal government, parts of which a federal judge has temporarily blocked, though don't expect that to continue very long, and has ordered the Justice Department and the Equal Opportunity Employment Commission to investigate programs in the private sector. Ames's case does not directly implicate DEI initiatives, but employment lawyers said a ruling for Ames and the backlash against DEI could make some companies think twice about their DEI programs. Companies are already thinking twice about their DEI programs. They know they're illegal, they know they're not constitutional. And there are multiple lawsuits against multiple companies, and that's even before the Trump administration came in, which is targeting all of these illegal hiring practices throughout the government, but also throughout private industry. One of the wild things about this story is this is a woman in the workplace we're talking about. She should not be discriminated against. No one should be, but I used to think that a woman would be a minority in the workplace. No, she's fine to discriminate against if she doesn't fit what the liberals want now. And if you don't stop discrimination in the workplace, here's where it ultimately ends. Major employers start hiring people who are not even U.S. citizens, and they discriminate against U.S. citizens, not giving them the same opportunity as even people from outside the country. From Zero Hedge, judge says Meta must face lawsuit alleging hiring bias against U.S. citizens. A federal judge has ruled that a lawsuit alleging that Facebook parent Meta favors hiring foreign workers over U.S. citizens can move forward. U.S. Magistrate Judge Laurel Beeler denied Meta's motion to dismiss the lawsuit, which accuses the big tech giant of systematically preferring H-1B visa holders because it could pay them less than American workers. The lawsuit, filed by 3 U.S. citizens, alleges that Facebook's hiring practices violate the law by discriminating against American citizens. The lawsuit accuses Facebook of abusing the H-1B visa program, which is intended to bring foreign workers into the United States to perform services in specialty occupations where there are insufficient U.S. workers. 3 plaintiffs allege they were passed over for jobs because Facebook preferred to hire foreign H-1B visa holders to perform the work to maximize profit. Quote, but while visa holders make up just a fraction of the U.S. labor market, Facebook prefers to hire visa-dependent workers for certain U.S. positions as it can pay these employees less than American workers performing the same work. The plaintiffs cited a separate lawsuit against Facebook by the Department of Justice that accused the company of discriminating against U.S. workers by reserving certain positions for temporary visa holders, including those on H-1B visas. To resolve those allegations, Facebook agreed to a settlement involving the payment of $4.75 million as a civil penalty to the U.S. government and up to $9.5 million to eligible victims of the alleged discrimination. As part of that settlement, Facebook also committed to revising its recruitment and hiring practices to ensure greater transparency and accessibility for U.S. workers. Facebook has denied the allegations and previously sought to have its case dismissed. It argued that the plaintiffs failed to prove any intentional discrimination or that they would have been hired if not for the alleged discrimination. The company also moved to exclude from the lawsuit any references to the DOJ case in the settlement because that looks kind of bad for them. But the judge in the case rejected Facebook's arguments. Quote, the plaintiffs are correct. Their complaint relies on more than the DOJ allegations, and allegations that Facebook favored non-citizen employees in another context are relevant to the plaintiff's claim. The court finds that none of the material that Facebook seeks to strike is redundant, immaterial, impertinent, or scandalous. Facebook also sought to pause the discovery process, arguing that it should not be required to turn over hiring data while its motion to dismiss was still pending. The judge also rejected that request, allowing the case to proceed. Accountability to employers discriminating against American citizens is coming to the country. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.